So I'm Kelly Swenseth. I have a law office just down the street from here. I deal primarily with farm families, being that we're in this part of North Dakota, and do estate planning, probate actions, a ton of real estate transactions, and business formation and succession planning. We also have an attorney in our firm that does criminal defense, because sometimes you need one of those. And we have an attorney that deals in primarily family law. So I have their business cards up here if you want to grab any. You are welcome to go to our website. It's swensethLawOffice.com. You can click to start intake, and that will get you on the path to become a client, or at least schedule an appointment so we can kind of discuss what's going on and have a consult and decide what your next steps would be. And then there's another option. You can just schedule an appointment. So we're trying to make it as easy as possible to get in and answer some of your questions as they come up. So I moved back to Devil's Lake in 2015, with this being the primary purpose is that I wanted to help farmers with estate planning. My dad works in the egg industry, and he said, you need to come back to North Dakota. I have people coming and sitting in my office asking me tax questions and estate planning questions, and I'm not qualified to answer those. So I've been back here for 10 years, and I think what I have seen over those years is everybody is putting off even starting an estate plan because they want to have it perfect from the first time. I want to let you know that that's not necessary. By delaying, what happens is then there's an emergency that may come up in the family and health crisis. And since you have not started any estate planning, we have to go to the court and have a guardianship done. A guardianship through the courts usually takes about 6 to 9 months and can cost over $10,000. That's because the person seeking guardianship needs to have an attorney. The person who you're seeking guardianship over has an attorney appointed. And then we have to have a doctor's report, a layperson's report, and somebody from social services, who are all going to meet with everybody, give a report to the court. We have to have 2 hearings. So it's a very drawn out process, and it's difficult when somebody is already experiencing a medical emergency or is hospitalized in nursing care. So what I brought today is the state of North Dakota has already, so to avoid needing to have a guardianship ever done, if you have somebody appointed as your power of attorney, that right there skips that whole process, that 6 to 9 months, that $10,000 legal fees, is if you just sign one piece of paper with a notary. The state of North Dakota has a statutory form, which I've gone onto the court's website and I printed a copy of that form together with the instructions. I only have 15 of them with me here today, but if you want to come and grab that and take that, that's your first step in getting your estate plan done. When you sign a power of attorney, what you're doing is saying that in the event of you either being on vacation in Hawaii, just not wanting to leave your house because it's just too cold outside, or actually not having the competency to sign a document, the person that you've appointed as your agent is able to do anything legally that you could do. So they can sign deeds, purchase agreements, mortgage documents, really anything legally or financially that you can do, they can step into your shoes to do. This is, I think whenever somebody turns 18, they should have this done. Especially with our, so this is not a medical power of attorney, but I think if you were to sign this and your agent presented it, doctors would still then be able to speak to your agent at least about your health condition and status. Because of the HIPAA requirements, a lot of our medical providers are very restricted on who they can share some of those updates with. So, it is a one-page front and back form. And then I have learned that the FSA office doesn't like our power of attorney form. So the FSA office has their own power of attorney form. So in each of these packets, if you are working in a farm program, you probably already have one, but just in case, I've also included a copy of the most updated FSA. You're not my clients and I'm not providing you legal advice today. I'm just providing you the forms that are available online. All right. So I'll leave these up here. If somebody wants an email, then you just want to give me your email address. I'll send them to you afterwards. So again, the number one thing I think for everybody once they turn 18, if you're a young farmer, working with a parent, I would have that would be what your project is to do before the end of January 2025, is to make sure you have a power of attorney over one another. So then I can talk about, if you guys have questions, you have me for an hour. I am here to answer any of those questions. You get free legal consultation here. Don't disclose. I don't want to know your personal information in front of everybody, but if you have questions specifically, please interrupt me or let me know. I'm happy to talk about those. But again, what I'm finding is that when I have clients come in who are farmers, they feel like it's overwhelming because there's so many things you have to think about. There's planning for taxes, there's planning for how land is going to be transferred, long-term care planning. And so what I often tell clients is, let's get something signed now as a placeholder, and then let's meet again after you've had some time to talk with your family members about what you want. Or I invite family members to come into some of these meetings so that they can talk with everybody who's involved in the farm to make some decisions so that everybody is on the same page. I know that doesn't work for all families, but that's usually my advice, is to communicate what your wishes are, so that when somebody passes away, people don't all take their toys and go over to every corner of the room and just kind of wait and see, ready to fight over whose assets are whose. So if you don't have a will, the state of North Dakota has a list of priority of who your assets are going to go to. If you have a surviving spouse, your surviving spouse gets 100% of your share of assets. If you have, however, if this is a second spouse and you have children with another person, then your children will get 50% and your spouse will get 50%. If you do not have a surviving spouse, but you have children, then everything would go to your children in equal shares. And so on. And I can go on, but the primary reason that I want people to have wills is to appoint somebody to be their personal representative. If you don't have a will and you haven't nominated someone to be your personal representative, who is the person that takes care of your estate after you pass away, then there's a list of priority, and we have to go to each of them and they have to agree, or the court decides who is going to be the appointed nominated personal representative. And until that's done, nobody can request letters testamentary. We can't do transactions. We can't handle your estate. So there's will. You can change your will every single day of your life as long as you have competency to do so. So you're not stuck with whatever you decide today or tomorrow. You can make up your mind to change as many times as you want. The last will that you sign is a will that will be presented to the court when we're opening a probate. The only type of, so there are trusts, and I don't do a ton of trusts for our clients, but it's always an option. An irrevocable trust is the type of trust that will provide long-term care protection or Medicaid protection. Long-term care protection, but if you do an irrevocable trust, once you have created that trust, you have created the terms of that trust, and you have put assets into that trust, it's irrevocable, meaning that we can't make any more changes to the terms of that trust. So that is the one type of planning tool that you can't, once you've decided, we can't go back and make changes. The other tool that we use is a life estate deed, which a lot of people come to me and they say, my aunt, my mom, my dad have a land trust. And typically, once we look at the deed records, we find that no, they didn't have a trust. It's a life estate deed. A life estate deed is a warranty deed from one person to another person with a reservation of all the rights to the property, the proceeds, rental income from the property, the obligation to pay taxes and take care of the property is reserved to the grantor until they die. This is also an irrevocable transfer. So because it's irrevocable, once that's been of record or signed for 5 years, 60 months, that provides Medicaid protection, meaning that once that has been in place for 60 months, it is no longer considered a countable asset that would have to be sold in order for you or the grantor to qualify for Medicaid for long-term care costs. That's not, I guess, one of the number one questions that farm clients have is, how do I protect my land from nursing home costs? I don't want the nursing home to come and take my land. That doesn't normally happen. The nursing home doesn't come and take your land, but they will if you are moved into nursing care and your family has no assets to pay, they have no cash assets to pay for your care. The nursing home can put a lien against all of your land until, so that once you have passed away and an estate has to be opened, then the nursing home can require your land to be sold in order to pay them back for the cost of your care. If you were to apply for Medicaid, and you qualify for Medicaid, before you ever qualify, Medicaid is going to look at all of your land titles, and they're going to determine whether or not there's been an irrevocable transfer that's been in place for 60 months. If there hasn't been, then Medicaid is either going to say you're disqualified from Medicaid benefits until after those 60 days have passed, or you agree that Medicaid can put a lien on your land, or you sell the land maybe to a family member or the operator of your land. And at that time, then Medicaid is going to require those payments or the value of that land to be paid to them or paid for your nursing care before you will qualify for Medicaid. And so this is a very complicated conversation that we have with almost all of our clients. I think when you are, starting in your 40s is when you want to start to think about what is going to happen in case I go into nursing care. There could be, a medical condition or an accident that could cause somebody to need long-term care. So to get that done and in place by your mid-40s, I think is a great plan. But it's an irrevocable transfer. You have the right to the income and the use of the property during your lifetime, but you can't take that back. If you could take it back, then Medicaid would make you take it back and sell it in order and pay for your care before you would qualify. Does anyone have questions? Yep.
How does a life estate gift go against your estate tax cap?
Great question. So I'm just going to repeat in case you couldn't hear. His question is, how does a life estate gift of land, how is that deducted from your estate tax? So when you do a life estate gift, when that deed is signed and drafted, my recommendation is to file a gift tax return that year. Use whatever the taxable value is per the county's records. Submit that to the IRS. And so you've made that gift, so that's going to start to count against whatever the federal estate tax is upon your death. In 2024, the federal estate tax was over $13 million per person. So it's okay to start borrow. If you have land and land is your main asset, let's get that done and that gift tax filed and that value locked in from the time that you did it. So that's all registered, but the IRS is aware of that. They have 3 years to come back and try to challenge whatever value you submitted. But the IRS doesn't have, I don't think, the time to review all of that or get back to you in that time. So once those 3 years have passed, whatever the value that you submitted at the time of your gift tax return has been sent, that's going to be deducted against whatever the federal estate tax is the year of your death. There is a chance that our federal estate tax is going to go down. This all depends on politics and who's in office. I think with this new administration, it's probably going to stay where it is and adjust up for inflation. But I hope not all of you die in the next 4 years. But if you've had somebody who has passed away recently that is transferring a large sum of money and they were married, there's an option to reserve any of their unused estate tax amount. That's called portability. And that needs to be, it requires you to work with your accountant to do an estate tax return for the person who's passed away. So that then you lock in any of their unused $13 million. Because if you have a husband and wife who pass away, if they pass away in the same year, husband gets 13 million, wife gets 13 million. Anything that goes from the husband to the wife is not subject to the estate tax. So that means that husband and wife can pass on 26 million plus to the next generation without having to pay a federal estate tax. North Dakota doesn't have an estate tax. So we're not really doing a lot of planning right now to like AB trusts type planning to work around some of those.
In a life estate deed, if the beneficiary passes away before the person who has the life estate deed, what happens in a case like that?
Okay, so the question is, if the remainderman, so the person who is the grantee in the life estate deed, if they pass away before the grantor, what happens? What would happen is the grantor is unable to cancel it. It would go to the grantee's estate. And then whoever would be their beneficiaries or heirs. So usually what my recommendation is, like if you have.
That estate may have to remain open for who knows.
Yes. Yep, and you can open an estate many, many years after death. So if somebody's passed away in 1950 and a probate was never done, but we still have land or a remainder interest in that person's name, we can wait and tomorrow file a probate. But if we file a probate now rather than back in 1950 when they died, their will is no longer valid because it was never submitted to the court. So then the state is going to distribute it to the grantee, the remainderment's beneficiaries based on North Dakota statutory law. So intestate law, if you died without a will. Normally, if I have husband and wife that are the grantors in that type of a situation and they're granting it to their children, you can give it to a child, give them a life estate, and then when they pass away, have remaindermen after their. So you could put your their grandchildren as a remainder, like second remainder owners.
But you can't set that up though until that first one passes.
Yep, you can.
That's not new.
I
I don't think it was like that 3 years.
there, if I am a grantee and I received a remainder interest in 2010, in 2010, even though it hasn't come to me yet, I can grant my remainder interest to somebody else. I can create a life estate with what I have.
Right, not a life estate deed.
Yep, I can. So a remainder interest is an interest in land that can be conveyed.
that
So
you haven't received.
yep, that you haven't received yet. It's a future interest, but you as the grantee, you have, as soon as that is recorded, you have the right to then prepare a deed to go to whomever you would like.
Could you require that the person you gave a life estate to put in their will that you would receive it back? Is that legal?
Yeah, I mean, it is yes, you can make a contract and that could be the agreement, but that person can change their will anytime that they want, and they don't need to tell you when they change their will. But if you trust that person and that's what they would do, then yes. Or sometimes I say, if, let's say, it's mom and dad and their son is a farmer, he is not married, does not have children. So I usually say, let's get your son, we need your son to come in or meet with an attorney to set up their estate plan or prepare another life estate deed that it would go from the son to a brother and sister or a trust or something else so that it can be managed and it doesn't go through that son's estate. Yes.
Was gifting a viable option to get your son into paying taxes? Because that's how I was told, if I sold him something, I'd have to get a appraisal and I'd have to pay the tax.
So gifting is, yes, you can gift. Are you married? So you and your spouse can gift each person, I think it's 18,000. It might be adjusted for inflation in 2025 now.
I was told it.
No, annual gifting, as long as it's under the annual gift exemption amount, which is $18,000 per person per. So you and your spouse could give $36,000 of value each year to, let's say, a son, a daughter, their spouses. So you can make their children, you can make those types of gifts each year. If it exceeds that amount, it's still not a taxable event. You need to file a gift tax return to say, I have gifted this much of my farm to my child, and that's going to count against whatever the federal estate tax is the year of your death.
You have to have appraisal done.
I would recommend, so I had just said earlier, you can use, if you submit that to the IRS and you're submitting, let's say you're transferring land, you can use the county taxable value or fair market, whatever they have as the value. You submit that to the IRS with your gift tax return, and they have 3 years to come back and challenge it.
But if you don't have appraisal, I think it's 7 years.
Is it 7? Okay, all right.
But you have to have appraisal, but I don't have to pay taxes. And does this include machinery and buildings?
So I'm not a tax advisor. I would say you need to speak to your CPA about what and how you're transferring. I know that a lot of farm families will trade in equipment, and so they'll trade in dad and mom's equipment, and then it will be financed by the child that's farming, and that's how I think a lot of machinery is transferred. I don't deal with a lot of that part of it. I may draft just the agreements that say that this is a transfer of those assets so that we have some documentation and what that value was agreed upon. But I'm not qualified to tell you the best tax way. Alex back here, she works for First Community Credit Union. And so she's if you have those questions, I would reach out. I mean, she's a great person. She does that with clients all the time, so. Yes,
Could you explain, say you're a farmer and you've got 15 quarters of land and you want to give your kid a start or at least get some ownership. You can quit claim deed 1/4, can't you?
yes. So the question is, can you?
Or any part of that.
Yes, can you quit claim deed during your lifetime? You can just deed it over, no life estate reservation. Yes, you can, but the reason you wouldn't want to do that is if you gift it during your lifetime, the value that is going to the grantee, for purposes of calculating capital gains, if they were to ever sell, their basis, you're transferring what your basis is to them. If you do it by life estate deed, so it only transfers at the time of your death, that's when title goes to the grantee, then their basis is going to be either the appraised value, fair market value at the time of your death. So they get a step up in basis. If they were ever to sell a property, that's going to be very important. That's a really good question. Thank you for asking. Yeah.
8 to 10 years to transition the farm seems reasonable.
Is 8 to 10 years of I think if you're communicating with everybody and you're discussing and updating as that transfer is happening, I think that's a reasonable transfer. Yes.
5 years.
It all depends on the situation and what the asset values are, I guess. It's so hard speaking at these events because everybody's situation is different. Everybody's goals and concerns are different. And so, but I think it could even make, yes, it could potentially be done in 4 or 5 years. As long as it's something that you're working on, not just doing something and then not doing it and then ignoring it for the next 5 years. I think, yes, that's possible. Does anyone else have questions? All right. This life estate deed thing is, every year that I speak, those are the questions that everybody asks. So if you have more scenarios or questions about it, that's what I'm here for. Actually, North Dakota is one of the only states that still allows life estate deed transfers to be considered a non-countable asset by our Medicaid. South Dakota will now go back and they'll respect the life estate grant, but they'll still say that the life estate owner, the grantor, they'll figure out a ratio of what their interest is in that land. And then they'll expect that to be bought out by the grantee. So it's a great thing that our legislature has continued to respect that for our farm families. Some of the other scenarios that have come up in my office, I guess, would be where there is a life estate deed to a farming child who's married, and then that farming child has not done any estate planning and maybe passes away. And then the parents are trying to deal with this going to a surviving spouse who is not part of the family, does not work in the farm, maybe doesn't even have children that would have an interest. So what you were essentially doing is you granted that farm to a son-in-law or a daughter-in-law that has no family connection and could go marry somebody else who then would take your farmland. So that can happen, and it does happen. I know we all think that who's older will pass away first and that our children are going to outlive us, but that isn't always the case. So I think that's really important to consider. And we talk about that often when we're drafting those life estate deeds with our clients. The other thing is, if you grant a life estate deed to a child who is married, and even during your lifetime, so you're still, mom and dad are still living, they're still getting the rental income, but son or daughter gets divorced. The son and daughter, whoever, their interest, their remainder interest in that land is considered a asset that will be equitably divided in that divorce proceeding. So if your child does not have sufficient assets to buy out the land part from their soon-to-be ex-spouse, then that land remainder interest could end up going to an ex-daughter-in-law or son-in-law. So we always talk about that as well. Sometimes it's unclear in North Dakota case law if you were to grant that land to a remainder owner, like a son, maybe two sons as joint tenants with right of survivorship. So it's going to go to two kids, and it doesn't, if either of them are married, it doesn't matter, their spouses aren't named, but it's going to go to them as joint tenants with right of survivorship, so that if either one of them were to pass away, it would go all to the surviving child. Then that, I think we could argue that then in a divorce proceeding, it's not guaranteed that either one of those remainder interest sons would get 50% of the fair market value of that. So in arguing in a divorce proceeding, you could potentially reduce that value in the divorce. So, and maybe this is going way, I don't like to talk about divorce or death with people, but those are the things that, I mean, they happen and we need to be prepared if that is to happen.
How about when you set up a trust? Say I have 4 children and I've named them all in the trust and I put all my land in a revocable or irrevocable trust. How do I protect that from divorce or premature death? You know, where one of those trust members died, does the marital interest go to non-named members in the trust?
So, okay. So the question is, if you have a trust that's set up and it's going, rather than going outright to a child, it's going into a trust for the benefit of maybe multiple children, then do the spouses have a claim against it? No. It depends on how the trust is written.
You can set
You can
caveats.
set, yes, you can set, a trust is up to you. I can write a trust however you want it written. There may be some IRS regulations and things you need to consider, but you can say that once that land goes into the trust for the benefit of, let's say, 4 children, if one of those children has an addiction issue, another child claims bankruptcy, another one gets divorced, you can set up the trust provisions to say that beneficiary's interest is not subject to any of their creditor claims. So it's protected. Once that money, so let's say each year, 1/4 of the profits goes to a beneficiary, then once that money is transferred to that beneficiary, then it's subject to their creditor claims, but not the whole land. So somebody can't come back and force the sale of the land. A creditor or bankruptcy trustee can't force the sale of the land because of the creditor issue or claim. That's a good question.
That would include a judgment.
Yes, so a judgment, they couldn't get a judgment against the land. The judgment would just be a personal judgment against that person. But because it's in a trust and there's a trustee that's managing it, at least the principal in the trust is protected from creditor claims. The thing is, so then you have to balance, if you're doing that, if it's a revocable trust or any kind of a trust where you can change the terms of that trust, then it no longer has that Medicaid look back protection. Because as long as you as a trustee can put things in and take things out, then if you were to ever apply for Medicaid is going to require you to take it out and pay them or pay for your care before you could qualify for long-term care assistance. So if you have long-term care insurance or you have another plan to use maybe your rental income, if you ever need to be in nursing care, if that's going to be sufficient to pay for your care, then you're fine. But those are all numbers we have to look at when we're making these plans with our clients. So if you put it in an irrevocable trust, I talk about irrevocable trust with all of my clients. I would say 95% of them cannot deal with an irrevocable, they can't give up the control of an irrevocable trust, because if you put land or assets in an irrevocable trust, once you put it in there, you don't get to be the trustee. You have to appoint somebody else that is not under your control to manage those trust assets for you. So you're going to have to pay probably professional trustee to manage, like be a farm manager for you. That trust is what's going to pay your property taxes. It's going to have its own tax return. So that is a drawback of doing that irrevocable trust for purposes of protecting your land from long-term care needs, is people just really have a hard time letting go of that control and giving it up to a third-party trustee. People always ask, can I just name my son as a trustee of an irrevocable trust? And the way that the courts and Medicaid see it is that as a parent, even if you're in your 80s, you still can control and tell your child what to do. So that is not with that life estate deed, but then we need to do additional planning so that we protect against, in case of the death of the grantee before the grantor. So, anybody else? Yeah.
I had one banker tell me that, the trouble with farmers are, it's all or nothing. And he said that, you guys gotta think that instead of putting all your land into a trust, you don't have to put it all in. Maybe you want to put part of it.
Yeah.
And put all these caveats and then deal with the next generation differently on the rest. Or
Yep.
do you have much of that?
Yes, I definitely have had clients who will put part of their land. Maybe it's their family's homestead, going back several generations, and that's what they want to make sure is protected. But then there's land that they have bought during their lifetime that maybe they don't have that connection to. And so sometimes then those properties, they either maintain or we plan for them differently. I think that the hardest part when I'm working with clients is that it's so difficult for them to make the decision about what land should go which way. And I think that's where that conversation usually, so I can't make that decision for a client. I'm here to do what they want me to do. I can advise them, but in the end, it's their decision. I'm here to draft documents and make sure that the plan is going according to what they want and need. And so usually that's where that ends is husband and wife say, all right, we're going to go look at all of our land and we're going to make a decision. And then 6 months we follow up and well, we haven't talked about it yet. And then years go by and that hasn't been done yet. So that's what I said from the very beginning is we need to start with at least some kind of placeholder plan, and then we can make plans. We can continue to work on it as time goes on. But I don't ever want somebody to come in and they're going to make all of these decisions that should take 10 years to transfer a farm, but they're not even going to start with signing a power of attorney or a placeholder will. We need to get that stuff done. That's what I wake up in the middle of the night and I think, oh no, so-and-so was here and I hope that they're okay. Like I would hate if something happened to somebody right after we met. So I worry about my clients that way. So I think it's important just to get something in place. It doesn't have to be perfect. And none of us have a crystal ball, so we can't, I don't know what year or how somebody is going to pass away or in what order. So that's why it's important to talk through some of those scenarios.
Do deal with much contract for deed?
Do I deal with contract for deed?
With
Yes.
fathers and sons and family?
I do, especially with when interest rates have been up lately, contract for deed has been a viable option to do some of those. But if you, one of the things I want to warn people about is for contract for deed is, let's say you give a contract for deed to your son and he's paying that, and then you need to go into nursing care. My understanding is that if that contract for deed is silent as to an acceleration clause, Medicaid can force you or your agent to sell off your interest to get paid under that contract for deed and then accelerate it. So then your child who had this plan that they're going to pay it off over several years, it's all going to come due right now. I haven't dealt with that, but I have heard from Susan Johnson-Drench, who is at JD Legal Planning, and she is one of the elder planning attorneys for North Dakota. She's warned other attorneys that is a contract for deed is not always a very good option because that is a possibility. Yeah, I mean, I haven't seen somebody selling off their right to be paid under contract for deed. Usually in North Dakota, that is just something we put down on your Medicaid application as income that is going to come to you. And all those payments for that land are going to go towards your care before Medicaid or the state is going to pay the balance. Yeah. Any other questions? You could just be a moderator here for me. Yes?
On that life estate deed.
Yep.
If I understood you correctly, you said it's still considered an irrevocable.
A life estate deed is not an irrevocable trust, although that is a very common, that's how people think of it. It's an irrevocable transfer. So
You can still change that period.
yeah, it's a beneficiary, but
Then the look back starts over again, but you can still change. it.
Yes.
Whatever the reason side of the beneficiary is what you thought.
yes,
You want to change it and the beneficiary agrees that maybe they're not responsible for handling.
Correct.
Whatever it might be,
correct.
you can still break it up. Just
Yes. So the question is whether or not, even though a life estate deed, that reservation of a life estate is an irrevocable transfer, you can't force, so there's no court or legal action that you can take to require that grantee to give it back to you. I mean, they could on their, they could decide they're going to transfer it back or quick claim it back to the grantor and cancel that life estate, but that starts over the 5-year look back period. I'm not sure what the tax consequences of that might be.
well, there was no exchange of any funds. Shouldn't have been.
It-
Tax implications.
Well, when you do a life estate deed, you should file a gift tax return, so you are registering what that value was at that time that you gave it. So I don't know how that would be
It's
reversed.
like that was ever.
And
It's not passed.
And- so it's not required, but it's the best,
Because
it's the best practice to do because yes, land changes value, but if you submit that, let's say in 2011, based on what your value, the fair market value was in 2011, let's say that's when you started that life estate deed, you're locking in what that value is then. So even though you don't pass away until 2075, when the land has increased in value, the amount that they're going to use to deduct from your federal estate tax amount.
But that doesn't matter until it hits the estate, and once the estate gets, then it gets new value anyway, so it really doesn't matter what it was in 2011.
So my understanding is if you do the gift tax return at the time of creating that life estate deed, you lock in what that value is. It's not reconsidered at the time of death.
Well, then there'd be no reason to do it.
So you're filing in order to lock in a lower value to go against your federal estate tax amount, exemption
Yeah,
amount.
that life estate deed isn't gonna go to your estate. It's gonna be
Yes, correct. The life estate deed isn't going to go against your well, the transfer of the land, even though it's not done through the probate process, it's still considered part of your estate that transferred at the time of death. So if you don't do the gift tax return at the time, then the value, rather than being at the time of creating that life estate deed, is going to be the value at the time of your death.
That's what you want. You want the value.
So if you're thinking for a stepped up basis,
Right.
yeah, so it doesn't have an effect on the stepped up basis for the grantee. It doesn't matter if you filed a gift tax return in 2011 or at the time of death. They're still going to get the stepped up basis. This is just to get that gift tax return done, so you're locking in the value of the land for the time of death. Because land values are always going to go up.
I just don't see the advantage in that when you create.
To me, because values of land are going to go up, you're going to lock in what the value is, which at a lower value rather than it being the higher. Yeah.
Well, it would be an advantage if you hit the tax exemption, if they lower
Right.
it down to 6 million or 7 million.
Correct.
Then it would be a big advantage, because
Yeah.
you'd have a lower.
Yes. So the federal estate taxes,
You're only gonna charge you that tax once you get over that.
but that 23 million, so that is right now, there's nothing to say that our federal government won't reduce that back down to 5 million is what normal, that's what, when I go to like, that's what they say to expect, that is going, eventually, because we have so much federal debt, our government is going to want to try to recoup that somehow. So likely, not in this administration, I don't think, but at some point that it's not going to stay at 23 million and continue to go up. It's going to get dropped back down likely to probably 5 million. And then land can be much more, like at the time of your death, your land could be valued at more than that. Yeah.
If you've given a life estate of some land,
Mm-hmm.
and now you want to change that life estate on that particular land to other land,
Mm-hmm.
and it was agreeable with both parties.
Yep.
Then it would be a like exchange, not as far as tax.
Correct. So what normally I would do, so the question is, if you decided that rather than this parcel of land going to a remainder person, and then this parcel of land going to another remainder person, you would like them to switch the land?
The other has to get. Well,
That-
that's just.
So it would be up to them. They would be the ones who would come in and they would do a quick claim deed and a like kind exchange between the two of them. And that continues, so because it's a remainder man that are doing that, that doesn't restart the 5-year look back period for the grantor. Normally, I would just do it as a quick claim deed, and when it's a quick claim deed, we don't have to put a consideration. Yep, so if they're both life estates, yep, this life estate went to one child and this life estate went to the other child.
No,
Oh,
it hasn't been given
it
yet.
hasn't been given yet? You want them to,
Switch
switch it?
from one. Similar
And-
comparable land.
Yeah.
Valley,
I think that, yes,
going through all that other stuff, would not be a life exchange.
it could be a like kind exchange, but then I don't know if I would do it that way, and because in order to qualify for a like kind exchange, it's not easy, it's not as simple as just saying, well, I'm gonna just switch this land for this land. You need to have a third party that is an attorney or like a CPA, somebody that's qualified to manage like kind exchanges. Yes, so you're going to have, you're just gonna have a lot more administrative costs to do that. It wouldn't be as simple as you just coming in and saying, I want a deed to transfer this. Yes, okay, all right. Yes,
How about the advantage and revocable?
okay, so the advantages or disadvantages of a revocable living trust. I think that a revocable living trust, the main disadvantage is that it doesn't provide look back protection for Medicaid purposes. Because if you are the trustee, or you have somebody else as a trustee who can take out for your benefit, then Medicaid is gonna require that trust, all those assets to be depleted before you would qualify. There are options to create supplemental or Medicaid asset protection trusts that we can try to use, but they're not guaranteed that they are going to do that protection. I think that we can write a revocable living trust that says, once you are disabled or you would qualify for government assistance, that 5 years from that date, it becomes irrevocable. So then at that point, whatever is left is protected. So we can do some planning like that. But I think, and we use this, if Medicaid protection isn't a main concern for a client, if they have long-term care insurance or they know they have enough income that could pay for their care for a number of years, then we will. I think a revocable living trust is a great tool for somebody who is a widower or single and in their older years, and they know that maybe I'm going to need somebody to take over kind of financial management for me. I think the revocable living trust is an amazing tool for that, because then as maybe somebody's cognitive function isn't where it needs to be, then their trustee just gets to take over. Without having to go to court, without having to change titles and everything. That trustee just simply steps in and starts signing for you. And then when you pass away, we don't have to do a probate at all. The trustee just continues to be in charge of those assets and follows through with whatever the trust terms are.
So the main disadvantage is just.
Medicaid, yes, yeah. And Medicaid is different than Medicare.
Yeah.
Okay. So yeah, it's the only reason, and that's almost all farmers. I know that like long-term care insurance is probably cost prohibitive for a lot of people at this point, and it doesn't pay out. I don't sell insurance, but I don't think that it pays out like what it did if you bought a policy in the 90s. Those policies, I think some of them still pay very well, and they're not limited in the number of years or the amount per day or something like that. What we have seen, I've heard a lot of conversations about is having a whole life policy and having the operating child in the farm pay that policy premium every year. So that if something happens then to, if the person who owns all the farm passes away, then that child has the death payout that then they can buy out any of their siblings, pay off any creditor debt or anything like that. So that is usually, that has been a planning tool that I have seen a lot with farm families. And when I've heard life insurance agents talking about it, what they're saying is generally for what the cost is for property taxes each year, your child is buying that life insurance policy to protect themselves so that land can come to them. I think some whole life policies as well, you can borrow against while you're still alive, you can borrow against a death benefit to pay for some of those long-term care costs. I think I'm at time, but if anybody has questions or needs any, it wants additional information, if you want to give me your email address or phone number, I can take that and I can send you our contact information, or you're always welcome to visit our website. Or if you don't want to work with me, I can definitely give you some referrals to other attorneys around the area. So thank you.